So, hello everyone, and welcome to our colloquy for week 4. As usual, this is the first part of our colloquy, which we'll be recording in Tumba. For this week, we're going to do 2 chapters, all right? Chapter 5 here in Tumba, and then in Springfield on Thursday, we're going to do chapter 6. And I've decided to continue with towards next week with chapter 23. This is one of the online chapters. That's going to be in Tumba. And then after that, we will start on contracts, chapters 7 and 8 in Springfield. Yes?
You still recommend we read all 3 chapters this week, though, 5, 6, and 23?
So it's up to you. Some people move faster than us. You know, they are already doing contracts. Some of you have already submitted your first online test. Some of you are already working on the second online test. That's why we call it heutagogy, so it's really up to you. Okay, so today we're going to start on what we call torts. For today, we're going to do, excuse me, for today we're going to do 2 things in particular. We're going to go through the summary for chapter 5, and we're going to weave through it our analysis of the case law that you see in your textbook. All right, let's get started. So the first thing I want to talk about is this idea of tort. Okay, it's a French word, as we said. It's an old French word that comes, it's similar to what we use still in English, like the word torque. And it simply means twist. So it's a twist or a wrong, and it's civil in nature. Okay? Why do we call it civil? Because it's distinguished from crimes. Torts are not crimes. Okay? Now, there are also other civil wrongs or venues of civil liability, in particular those of contract. So when we get hopefully to the tutorials today and moving forward, we'll always remember that our starting position is those 2 chopsticks that we talked about earlier. So just quickly. So we always said liability will go through 2 routes. One is criminal, and we already talked about that last week. And the other is civil. So we have criminal law and civil law. Under criminal, we already discussed, if only briefly, the theory of crimes. Under civil, we're going to discuss mainly 2 theories. The first is today's torts. And after that, we're going to talk about contracts. Okay. So for your purposes, of course, which one of these you use depends on what you want. If you want punishment, you would go for criminal law. If you want compensation, plus other things that you could do, you would go under civil law, and then you have to decide whether you want to go under torts or under contracts. Okay. So as it says on page 119 of your textbook, what you get, the remedy that you get is damages. And damages refers to monetary compensation. So remedy is defined on page 119. It says a remedy is a form of relief Okay. So we want this part, and it says a remedy is a form of relief, generally in the form of monetary compensation, which we also refer to as damages, that a person who has been injured by the actions of another is seeking. So you're not seeking punishment, you're seeking money. Sometimes an injured party will want some other form of relief, other than monetary compensation, and that's going to be discussed in some more detail when we get to contracts. There are also some other types of relief in chapter 23, but we'll leave them for now. Okay. Let's look at some distinctions between criminal law and contract law, criminal law and tort law. Because criminal law, as we said, is the criminal part under criminal law, it has to be to a higher standard of proof, which we call beyond reasonable doubt. Because torts are civil law, they need only to be proved to the standard of balance of probabilities, which is much lower than the criminal standard. Under criminal law, you want to punish the offender. Under torts, you simply want to compensate the victim. Okay. Consent is irrelevant under criminal law, while consent under torts could be one of the counter premises or defenses that you could raise. In criminal law, it's the Crown that's going to be the movant, while in torts, it's going to be the individual. Now remember, we talked about different legal systems when we started this course. This is the common law approach. This is the Australian approach as inspired by English law. Other legal systems actually criminalize torts. Okay? So the distinction is still in existence here in Australia between crimes and torts. Then we go down to the civil liability area, where you have contracts or torts, and they are also still different from each other on two dimensions. The first is promises. Contracts create rights and liabilities, okay, that are specific to the parties of this contract. So they are created by the promises that these parties exchange as part of their agreement. On the other hand, torts create rights and responsibilities without the need for any promises. These are basically your rights and responsibilities as part of this society. Again, under contract law, you require something called an agreement. So when we talk about the existence of contracts next week, we will look at three elements under this theory of existence, classical theory of existence for super contracts. And there you'll find that you require, the first element is agreement, while torts do not require such an agreement. Okay? So as it says, tortuous duty is imposed independent of the consent of parties. Okay. So what's the difference again between torts and crimes and torts and contracts? We just covered that. So basically we're saying tort law is concerned with compensation, criminal law is concerned with punishment. These are the take-home really points, so keep that in mind. Tort law is concerned with the enforcement of rights, while contract law is concerned with the enforcement of promises. Of course, promises are going to create rights, but we don't really refer to them as rights in that sense because they are specific to the parties to the contract. So we've already covered this slide. So this is the one that you have on page 118 in terms of the differences between criminal law and tort law, and then between contract law and tort law. So now we come to the idea of negligence. This is, of course, a legal theory and a cause of action. But before we start on that, I just want to remind you of something called the period of limitations, which applies to each and every action that you wish to bring to the courts. Okay, so there's a time period for tort actions, and we have this table here on page 120. Okay, so these are what's known as the limitation acts in each one of the different jurisdictions in Australia. And it tells us simply that if you want to bring a cause of action on that legal theory, so for example, the third column talks about personal injury, so in terms, for example, of battery, or negligence, which is the case we'll discuss right now, or nuisance or trespass, then you have 3 years. You have 3 years, okay, to bring that cause of action to courts. After that, you lose your right to do so. And you can think of the practical reasons for limiting that cause of action. And of course, it depends, on the theory or the cause of action itself. Defamation has only 1 year. Okay? And there are also other torts, and those usually would have more time for you to bring to the courts. The same thing applies in relation, as I said, to any cause of action, including contracts. All right. Just quickly again on this time limitation period. It depends on whether, when we talk about torts, it depends whether the tort is a tort that is actionable per se, meaning that you don't have to prove damages for you to argue that cause of action, or it could be like negligence, one that you need to prove that you have suffered damage for. Okay? So there was harm or there was hurt, and because of that, you can argue negligence. If it's the per se variety, okay, the time period for the limitations purposes starts from the act itself. Someone hits you, for example, that's the starting point for counting the 3 years. That's going to be, I think, more than 3 years because it's assault. But that's the time where you start counting the act, counting the period. If it's negligence, on the other hand, the period starts not from the act, but from the time you have suffered the harm. Okay? So the 3 years for negligence starts from the time you have suffered the harm. And why is that important? Because sometimes the harm could come in the nature of a psychological effect that might take some time before it actually develops into symptoms that we can identify as relating to the act. So this is just a minor point. We don't have to worry about it too much, but remember that you have to look at, when does this time period for limitations starts, but just a passing note. All right, let's look at negligence. Negligence arises in 2 ways. Okay. So the starting point is on page 122, and negligence could either arise from an omission, so something you should do and you did not do. And why should you do it? Because on the objective reasonable person test, you have seen this before, a reasonable person would not have omitted doing that thing. For example, you're cooking at home, okay, and you leave the fire on. Maybe you are frying something, and the oil catches fire, and then the whole house burns down. You've omitted to do something. Or you have done something that a reasonable person wouldn't have done. For example, you are using an electric plug, an outlet, and you have connected it to a very high electric load. And because of that, you've caused a breakdown in your electrical circuits, and that caught fire, and again you ended up burning the home. So negligence then indicates a failure to exercise reasonable care and detail, reasonable care and skill. Negligence, again, is a legal theory. So we are going to look for its elements. Last week we talked about the theory of crimes, and we said a crime must have two elements. The first element was the actus reus, or the wrongful act, and the second element was your fault element, which we refer to as the guilty mind. Okay? Sometimes it could be the mens rea in terms of intention, but it also could be of other types. Our theory today, which is negligence, has three elements. And you'll notice as we go through the course, the next theory is going to have even more, total of 7 elements. Remember, elements are necessary. See, necessary to establish negligence. So you have to prove each and every one of these. Because it's civil law, you only need to establish each one and every element of these each one of these elements to the balance of probabilities, which is a lower standard than the standard we've seen last week, which is beyond reasonable doubt. In terms of probability, in terms of percentages, so something like 51%, 55%, just tipping it over to the other side, that should satisfy the balance of probabilities. There is no hard and fast calculus in terms of numbers, for example, but it is the idea that when you argue these in court or you write your arguments for an answer on the exam, the marker or the judge in that case would be convinced on the balance of probabilities that you have made that element. Beyond reasonable doubt, much higher, so it has to be really maybe like 80%, 90%, high probability that you have made the elements of a crime. The first element talks about existence of a duty of care. You have to convince me that if you are the plaintiff, remember, the Crown is not involved. So all the costs of bringing the cause of action will lie on you. Of course, there's also the element of insurance, which means that you can also externalize that cost by taking out insurance. So the insurance company would go through the exercise. But the first element is that there has to be a duty of care on the defendant to the plaintiff. We'll take exercises and we'll take some of the case law to explain more what we mean by that. Once we have established that a duty of care exists, you need now to argue that that duty has been breached. So the defendant owes me a duty of care, and by a certain omission or a certain act, they have breached that duty. In the same sentence, you see that we're talking about consequences. Because negligence is not a per se tort. Regardless of whether there's a duty or not, regardless of whether that duty has been breached or not, there has to be harm. If you haven't suffered harm as the plaintiff, there's no point of bringing this type of action. And if the harm is de minimis or of minimal consequences, then all you will be able to achieve out of all of this is what's known as nominal damages. So you would get $2 for your efforts. That's all the money compensation you're going to get. You might want to spend maybe $5,000 in legal fees, but you will end up with $2 in your pocket. So always remember, you need consequences. So you as a plaintiff suffered this actual loss or damage, and that is a damage that's recognized by the law. Sometimes this damage is physical. So because of something that someone did to you, because of an omission or an act, you suffered certain burns, or you broke an arm. That's what we mean by damage in terms of physical injury. Sometimes the damage is of an economic nature. You're a company, and because of something that someone did or did not do, you suffered economic loss in terms of loss of market share, or even maybe in terms of loss of profit. Sometimes the damage is in terms of psychiatric injury. It's not something physical that you can see as in, for example, a broken arm, but it's still an injury that sometimes the law might recognize. That will start giving you a problem, a difficulty with this duty of care, not as much as proving the damage itself, but also the existence of the duty. So it goes back to your first element. That's what you need to remember for exam purposes. So when you do your Part B exam questions, which most people fail, remember that you need to start with these elements. This time around, hopefully you will, because it's an open book exam for the first time. And that's not the end, that's just the beginning. Once you have established that you want to talk about the premise of negligence, you will have to put the elements, and then you will have to think of which one of these, based on the facts, is going to create a legal issue. All right. Now the analytical structure. So this is again the idea of how you write, how you read your textbook. The most important part so far is the analytical structure. This one. So this is your figure 501, 5.1 on page 124. So we call them steps in this diagram. I call them elements. It doesn't matter. What matters is that you have to go through these three, and you have to make each one of these. So let's just take them quickly. We said if you fail on any of these elements, then this cause of action is going to fail. So this is like a flow chart. If you go with yes after you answer the question, does the defendant owe the plaintiff a duty of care, and you answer yes, then you continue to the second element. If you answer no, then you're done. You are not going to get any money. You're not going to get any compensation. You're not going to get any damages. So you might as well. So that's what really lawyers do. They would actually analyze things before going to court to establish the probabilities of actually getting something out of that in terms of money. How do you establish whether the defendant owes the plaintiff a duty of care? How do you answer that question? Well, you answer it by asking more questions. And these more questions are what we call legal tests. The legal test in relation to the existence of a duty of care is referred to as reasonable foreseeability. So the question you would ask was it rather reasonably foreseeable that the defendant's conduct, i.e. omission or action, could injure the plaintiff? Okay. You'd also ask, was there a vulnerable relationship, i.e. position of reliance from the plaintiff towards the defendant? So the plaintiff was vulnerable to the defendant. Or whether there are any policy considerations that should, so it's normative, prevent the defendant being held liable to the plaintiff. So sometimes some of the policy considerations could be cost, what we refer to as the floodgate argument. If I find this defendant liable on these facts, how many more people are going to line up asking for money for some similar facts? And what is that going to do to the viability and profitability, especially of businesses, and in many instances as well of local government? So you'll find that the courts will not find liability, even though they should, because they're afraid that more and more people are going to ask for money. Later in the week, we're going to talk about some reforms that occurred in this area. In particular, something called the IPP report that talks about exactly the same point. The idea that at an earlier stage, there was a high water mark for people who wanted to apply for monetary compensation using negligence. And that put pressure on insurance companies, meaning that the premiums went up, and some SMEs, small, medium enterprises, were squeezed out of the market because they couldn't afford the premiums. So we'll talk about it more later. Let's go back to this slide. In terms of identifying legal issues, this is the existence. This is the first element. I want you to remember that there are three categories. That's the first element, but we're going to try to figure out where the legal issue would arise. The legal issue arises only under this category. In other words, there are already precedents that tell us that the duty exists. So, depending on the relationship between the plaintiff and the defendant, or between the parties, we know already that there is a duty of care on the defendant towards the plaintiff. So we'll find these detailed on page 126. Okay. So this part here identifies for us typical relationships where we know that a duty exists. So examples of these settled cases where you have a manufacturer of goods and a consumer. We'll talk about Donahue and Stevenson in a minute, one of the cases that established that category. Okay. But for our purposes, that doesn't create a legal issue. We know there's a duty. Also, between employers and employees. This is an important one. In fact, the relationship between them is even of a higher standard that we call a fiduciary relationship, high level of trust. Also, things like motorists and road users, teachers and students, councils and those using their facilities, like recreational facilities. And one of the also important categories is this one here, which we will unpack more later in the week, which is the duty on occupiers to anyone who comes on to their property. There's the duty between the professional and their client, prison authorities and prisoners, and so on. The point is, if you are presented of any of these relationships, then all you have to say is that on the first element, a duty exists based on precedent. And in the textbook, there are examples of more or less all of these relationships and how they give rise to that duty. Now, there's also another settled case where the duty does not exist. Technically, the duty exists, but the defendant has immunity. So, you will find these immunity cases, categories. So it says, in addition to established categories of duty, there are several categories of immunity because of policy considerations. So, armed forces, for example, have this immunity. Children protection agencies, the police, fire brigades, barristers, but not solicitors, And there's something also called statutory immunity because of the civil liability legislation. So you are given immunity by a statute. Sometimes that immunity could be in very subtle ways. For example, there could be a parent organization, and that parent organization has a subsidiary. So they fully control this other organization. But this parent organization was created via an act, via legislation. And in the act, they simply say that this subsidiary is neither the employee or the agent of this parent. So what have they done? They basically eliminated at least some of the settled cases for finding liability on the parent company. Just remember that sometimes we can establish immunity or remove liability through statutory instruments. For our purposes, when you get your exam question, just remember not to spend too much time if what you are looking at, for example, the scenario talks about a manufacturer and consumer, or employee and employer, then you know that's an existing duty. So you just say this is one of the established duties, 2 sentences. Maybe you can reference also one of the cases. It's only when you have the novel cases that you have to go on and analyze more. Analyze more what? So you need then to go and ask the other questions that we have just looked at. Sometimes I have hard time locating the exact page. Here we go. So this is our first step. You don't have to go through all of these questions if this is a settled case. Okay? You only have to do this if it's a novel case. Then you have to go through the analysis of reasonable foreseeability, the vulnerability, and the policy considerations. Okay? So far, so good? Any questions? All right. Let's then continue with the second step. First. So, just a rehash. Under what circumstances the defendant owes a duty of care to the plaintiff at common law? Why is it important to say at common law? Because in Australia we introduced a legislative intervention under the Civil Liability Acts, such as the one in Queensland of 2003. Because this is an introduction to law, we don't expect you to go and look at those acts or to really know much about what's going there. What you need is going to be given to you in the flow charts that we're going to look at. So again, if there is a novel case, we need to look at the forcibility test, the first question in the flow chart, then whether there was vulnerable or dependency relationships between the defendant and the plaintiff, the second question, And finally, whether there are any policy considerations that prohibit us or prevent us from finding liability. So let's just say a few things about these civil liability acts. As you see, most of this intervention came through in relation to the second element. It's not the existence of the duty, but the breach of the duty. So the second element is the second step here. So has the defendant breached their duty of care? We found that there's a duty of care. How do you answer this question? By more questions. And these are the legal tests. So a legal test is basically a question. First, was the risk foreseeable? That is, was it a risk which the person knew or ought to have known about? Who's the person here? The defendant. Was the risk not insignificant? You'll find that many times when we do in legal writing, you'll find what we call double negation. So it's always that way. So start getting used to it. Not insignificant. I could just say it was significant, right? Was the risk significant? But the emphasis is on insignificant, because we want to see whether it was so minimum that a reasonable person wouldn't expend time and money to try to reduce or eliminate that risk. And that's why we call it not insignificant. The emphasis on looking at the lower end. And we continue our analysis by asking, in these circumstances, given the facts, would a reasonable... someone needs to mute their mic, please. Shanae or someone else? Thank you. So, the last question is, in the circumstances, would a reasonable person in the defender's position have taken precautions, i.e. have taken precautions to reduce the risk that eventually resulted in the injury to the plaintiff? Now, if we go and look at a more detailed analysis of this step, on page 139. So for the purposes of the exam, it would be a good idea to just photocopy this page. Don't rely on taking the whole book with you. It's just to our exam, to make sure that you can find the information you need. Let's look at the same step, but now with the Civil Liability Act's intervention. So we're looking at this elaboration on what we just talked about. Again, it's the same question. Was there a breach of the duty of care by the defendant? So you find that these CLAs, Civil Liability Acts, have sections on the content of the duty of care. In Queensland, for example, you got Section 9. and gives you more information on that content. And out of that, you're going to ask the questions, was the risk foreseeable? That's the first question. That is, was it a risk which the person knew or ought to have known about? If you go with the yes, so the idea is that you are going to use the facts that are given to you and answer that question by analogy, for example, because something is similar to something else that you have read, or just arguments from what would the alternative look like and what would be more reasonable. Remember, here we're talking about whether the defendant knew. Okay, so this is factual. Because of the facts that are given to you, you can see that he knew about this risk. Maybe because something similar happened in the past. Maybe because something similar happened in the past. Or they are ought to have known. And that's where this idea of reasonableness comes in, because we are really talking about the normative part. What should be. As a reasonable person, you should have seen that. You should have known. Once you clear that first hurdle, you go to the next question, was the risk not insignificant? Okay. We're going to look at some examples so that we can flesh out some of this. And the last one, of course, in the circumstances, would a reasonable person have taken precautions? So there are factors to take here. These are not elements, these are factors. So you need to at least make a few of these in order for you to go one way or the other. So things like the probability that the harm, i.e. the injury that happened, would occur if care not taken. This is still in the abstract, so we'll take some examples. Likely seriousness of the harm, okay. Burden of taking precautions, financial burden, to avoid the risk of harm, and the social utility of the activity that creates the harm. Okay. Other principles were introduced by the CLAs. So you could see, for example, in Queensland, you have section 10 of the CLA. So you can go there and have a look at that as well. And finally, you end up, this is just the second element still, with whether D has breached their duty of care, has B suffered damages. Okay? All of this is in relation to the breach. Now we are ready to go to the last element. First, let's just talk a little bit more about what the CLAs have done. So there are two stage tests under the CLAs, again in relation to the breach. As we said, the first one talks about reasonable foreseeability. Was the risk reasonably foreseeable? And then the factors we've just looked at in terms of probability and the seriousness of the harm and the social utility and so on. In order for us to establish that there has been a breach of the duty that we found to exist in the first element, we need to agree on what standard of care applies. Think of this as the hurdle. Okay? We found that there's a hurdle in the first element. There's a duty. Now we want to know how high or low that hurdle is. Because once we establish where it is, high or low, we can then decide whether the defendant breached that duty or not, i.e. whether they have cleared it or not. So there's a standard of care. The key point is that this standard of care is a flexible standard of care. Again, it's the objective test, but the key point in relation to the standard of care is what you find on page 136 that explains to us that this standard is flexible. What does that mean? So, it's flexible in terms of the defendant. The hurdle that someone who is a child, for example, needs to clear, whether to be found in breach or not of the duty, is different from a standard of care that an adult would have to clear. So the idea here is the standard of care flexible? Okay. So it says, for example, at the bottom of that paragraph, in an action in negligence, where the plaintiff is a passenger who has been injured in a motor vehicle driven by the defendant, the relationship of the parties is simply that of the driver and passenger. Okay? In that case, the standard of care required is the degree of care of an experienced and competent driver. Let's go through this Embry case to explain that further. I will go back to Donahue. Once we've covered the three elements. This is from 2008, High Court of Australia. It says HCA 40. What does 40 refer to here? Page number? Or something else? Is this natural reference, natural citation, or a reference to a law report? Anyone? What is HCA? High Court of Australia. Is High Court of Australia a law report? No. So, we call this natural citation, which started since 2001. Anything after 2001 is most likely they're not going to be with natural citation. And the 40 refers to the case number in that year. So that's the 40th case reported on, i.e. judgment delivered on in 2008. Okay, the facts. Embry was a passenger in a vehicle driven by McNeely, the 16-year-old friend of Embry's son, Paul. According to McNeely, he was traveling at around 70 to 80 kilometers per hour when he noticed a shredded tire on the road. He's 16, right?
No, the passenger is 16.
Yep, that's correct. So let's read again. Embry was a passenger in a vehicle driven by McNeely, and McNeely is the 16-year-old friend of Embry's son, Paul. So who's 16?
The driver.
The driver. If you are 16 and you're driving a car, what would you do when you see a shredded tire on the road?
Probably slow down and try to avoid it.
Okay. What do you do if you see a wallaby?
Again,
Slow down and try to avoid it? You? Don't swerve. Okay? The most important lesson you learn as an experienced driver is you never swerve. Whatever you see in front of you, if you can't slow down, just go through it. That's your safest option. Human being? Because if you are, and that's why people die on the highways, because the driver cannot do much, because there are the cars coming through. Instead of killing one person, you end up killing 10 people. In trying to avoid it, the story goes, this is a real case, he moved to the left, and as he did so, the vehicle moved off the edge of the road. He tried to correct the vehicle, but lost control, and Embry sustains several injuries. This is physical injuries. McNeely did not have a driver's license or a learner's permit. Do you think there's a duty of care here between these two people, between Embry and McNeely?
No, because I don't think McNeely was the driver, right? He shouldn't have been driving in the first place because he didn't even have a learner's permit.
Okay. Is this how we establish whether there's a duty of care or not?
No.
how do you go about answering the question whether in fact there is a duty of care between these two? So what did I just talk about earlier?
Because he was responsible for driving the passenger?
Yeah. Here we go. We said that these are categories where there is a duty on the defendant towards the plaintiff. Do you see anything here that you could use? Some people go and say it is actually the third one where you have a motorist, so the driver, owes a duty of care to the other road users. Was Imbri an other road user? In what sense? So she was using the road because she was a passenger. Does she have to be in a different car? Does she have to be another driver? Okay. Any? Yes?
Fourth one's also follow right other duties that passengers also being interpreted for calamity.
So someone says it could be also an analogy between a boat captain and the duty that they owe to their passengers. What do you think?
Well, I think that could apply because people might say, oh, that probably only applies to the ocean. But boat captains, well, a driver of a car, you're essentially the captain of said car. And yeah, you do owe a duty to your passengers, who are people on the passenger seat or in the back.
So if this was a question in the exam, and you are analyzing whether a duty exists, any of these options would be great. Because all I need to see is that you can think critically. So you could go saying there is a duty of care, or a duty of care exists on McNeely towards Imbri because this is one of the established or settled cases. In particular, there is a duty of care between the motorist and the other road user, and then you explain why Imbri is another road user. Or you could go and say there's that analogy between the boat and the car where a boat captain owes a duty of care to the passenger. And why you think that this analogy between the boat and the car is important. Anything else?
I was going to say, I was going to argue that maybe professionals owe a duty to their clients, but I guess I was going to say the passenger sort of owed, he was the professional driver or something, he owed a duty to his...
He's not a professional driver. Great, thank you. So Tim, right? Tim says, what about occupiers owe a duty to persons who come on their property? So, can you just unpack that for me? He says, I think we can make this analogy between these occupiers and the duty that they own to persons on their property. So who's the occupier here?
The occupier is the passenger. Oh, sorry. The occupier is the driver
Why is the occupier the driver?
because he's in control.
He's in control. I'm looking for that word. Control. Who's controlling the car?
The driver.
So he's the occupier of the car. So the car in this case is the property.
Yeah.
And who came to that property? The passenger, which is Imbri. Any of these arguments would be great. The key thing, don't go and say, oh, this is a novel case. So let me go and just go through all the questions I've talked about in the breach, in the existence. Okay? All right, let's continue with that. Where are we? So we just have to go back. All right. So the issue then is not the standard, the issue then is not the existence of the duty. A duty exists. You can argue it in many ways. The issue is whether there was a breach of that duty. You have to cover all three elements. You are in the second element, and that's where the issue is. And why is that the issue? The issue is, what should the standard of care be? We have the 16-year-old, doesn't have a driver's license, doesn't have a learner's permit. When I go and apply the standard of care, my reasonable person, what is he going to look like? A professional? So they decided there should not be different standards of care. A learner driver is still subject to the same objective standards of care as another driver. This is really a standard answer from the courts. If someone is crazy, if someone has a mental illness, do you think the standard of care that the court is going to apply to them is going to be different from the reasonable person? No. Even though you can prove that there is something that prevents them from getting to that high standard of care. Courts are going to resist that. They will still apply the same standard of care to the reasonable person. So it's not the only one that they talk about in this uniformity. So, by a 6-to-1 majority, that's a big majority, the High Court held that its 1986 decision, in which it had held that the standard of care owed was what was reasonably expected of an unqualified and inexperienced driver, should no longer be followed. Just like Mabo, okay? So this was in 2008. Remember, the High Court of Australia is not bound by its precedents. They looked at this precedent and they said, what? We're going to overrule it. Or rather, it's not going to be followed. Why? They said the driver of a motor vehicle, irrespective of their experience, and regardless of their relationship to the instructor, owes a duty of care to all third parties to drive with reasonable care. Let's look at the case reflection. If an accounting firm, it's not a car accident anymore, assigned an inexperienced trainee accountant, when you graduate, they assigned you to prepare the books of account and tax return for a client, would this firm have satisfied the standard of care of the average, fully qualified accountant, or the standard of care of an inexperienced trainee accountant, and why? Let's give someone else the chance, please. Thanks. I know you're going to contribute very well, but let me go to people who haven't heard from today. Someone else, please. You have graduated from this university, okay, as an accountant. You go to a big firm, Deloitte, for example, PricewaterhouseCoopers, whatever. And they give you this job where you are assigned to this firm to prepare the financial statements, let's say. Have this firm breached any duty of care towards the client? Now we talk about this duty of care between the professional and their client. There's a duty of care on the firm towards its client. Is it breached if I take one of you and assign them their books?
Yeah, as long as it's either side.
So you say yes?
As long as it's an oversight.
An oversight.
Yeah.
So they didn't actually intend to assign an inexperienced trainee. Well, not one of you. Let's just say an experienced trainee.
You'll be under the supervision of an experienced person.
Okay, so he's saying I can assign an experienced trainee, but on what condition?
Should be monitored.
They should be monitored. Which means what? Who has control? The firm or the trainee? The firm. If I take you, for example, to a TAFE, where they have hairdressing classes. So you can go there and you can pay less and they will make your hair for you. What is it that they have to make sure is satisfied in order for them to escape liability if, for example, someone asks for a perm and then they damage the hair? What should they do? What do they do if you have seen something like this? What do they do when you go to those places?
They ask you what you want.
They ask you what you want. Who's going to do the work? Who's going to do your hair?
Hairdresser.
The hairdresser. The hairdresser is what? A student. In order for them to escape liability, what has to happen?
You have to be fully aware that it is a student.
So you have to be fully aware that he's a student. So you're happy with the risk. So if something happens, we're not responsible. Is that how it works? Has anyone been to these places? Has anyone used such services? So what is missing in this scenario? The student is with whom?
Teacher.
With a teacher. And before they do anything, they have to do what? They have to discuss it with the teacher. And you are listening. Everything is happening in front of you. Once they agree and you know you're happy, then they start. At every step, the teacher comes and checks. That's what we would expect of something like this. It's okay to bring someone trainee to train. You check into a hotel. And you want to check out. You produce your credit card and you go to the person and you say, could you please help me check out? And you notice that next to the name tag, there's another tag that says what? That says what? Trainee. Are you alarmed by that? But what has to happen as well? What do you also expect as a reasonable person? This is a trainee. What do you see in the photo? What do you see in this mental image? There's another person. And that's always how it works. Either the other person checks you out and the trainee watches, or the trainee checks you out and every step of the way there's someone else watching over them. This is what we mean by the standard of care. Okay? Sometimes the standard of care is going to be flexible, but also the flexibility has limits, as we saw in this case. Let's move on quickly to the third element. And then we'll do some analysis on the cases. So this is the third element in relation to causation. And we want to look at the flow chart on page 144. So far, we said the first thing is the existence of the duty. And we said that there are either established cases where there is a duty or there's immunity, or novel cases where you have to do some more analysis. Once you establish the existence of the duty, you go to the breach. For the breach, we have to understand what is the standard of care. And then you would argue whether that standard of care has been met or not. Once you find that there was a breach, i.e. the standard of care has not been met, you move on to the third element and the last element in the premise, where you would argue whether there were damages or not. And how do you answer that question? Again, with more questions. The first, has the plaintiff suffered actual damage or actual loss? So you have to prove. Okay? You have to prove there were, in fact, actual damage. Not damages, damage. Actual harm. A broken leg. Yeah? Loss of money or income. And was the damage caused by the defendant's breach of duty, which you found previously, which is what we call actual causation. So this is based on the facts. You're looking at the facts. And was the risk reasonably foreseeable, i.e. not too remote? And we will find that the CLA gave us some arguments around remoteness, because now we talk about what we call the scope of liability. Okay. All right. All of this is going to become clearer when we start looking at some of the exercises or some of the cases. Again, what is the importance of causation and remoteness? Now we call it scope of liability when applying the relevant sections of the CLA. So the plaintiff must establish that the defendant's conduct caused the personal injury or whatever harm. There must be actual damage, and this raises two questions. The first is the factual causation. Was the damage directly caused by the defendant's breach of their duty? Again, this is a question of fact. Or, if factual causation is proven, if factual causation is proven, is it appropriate to extend this scope of liability to the harm so caused? The first part of the analysis looks at the focus is on the conduct, either the act by the defendant or the omission by the defendant. The scope of liability is going to focus on the consequences. Whatever they did or omitted to do, what were the consequences? Okay? Note that this is a value judgment. Have we spoken about value judgments previously? Yes, we did when we looked at ethics. At the end of it, when it comes to the scope of liability, you have to have a value judgment. So you have to import some of the societal standards that would tell you something about whether this should be covered as liability or the defendant should walk without liability. Quickly, now we finish the premise. So your book continues to talk about these things as steps 4 and 5. For our purposes, this is now the counter premise. Once the plaintiff has proven the 3 elements, there is negligence, but the defendant could still walk without liability, i.e. not having to pay any money. If they can prove something called contributory negligence, so even though the plaintiff suffered harm, they contributed to their harm. They have done something or omitted to do something because they are negligent that contributed to the harm that they've suffered. Previously, if you could prove this, you pay 0. You pay nothing. After the CLA intervention, this became a sliding ruler. So you could pay 0 or you could pay anything between 0 and 100, depending on how much contribution came from the plaintiff. The other defense is what that person there said in relation to when I talked about the hairdresser, that you accepted the risk. Okay? This is what we call voluntary, it has to be voluntary, assumption of risk. Did Embry know that McNeely, did Embry know McNeely? Or was this some sort of an Uber driver?
He was father or something.
He was
He was the friend. He was
her
friend to his father, to the driver's father.
Okay, is it fair to say they knew each other? Is it fair to say that Embry knew how old McNeely was? Is it reasonable to say they knew that they did not have a driver's license? That they were not, they did not have a learner's permit? If that's the case, let's say yes. Then you have made this defense. McNeely would turn around and say, voluntary assumption of risk. You knew. You knew I'm 16, but you agreed to get in the car. You knew I don't have a driver's license, but you agreed to get into the car. And you knew that I don't have any learner's permit, but you still got in the car. So I made an accident. You know the risk. You know the risk. So you could argue it's a voluntary assumption of risk. There are, of course, obvious risks. Was this an obvious risk to Embry? That you are 16, that you don't have a driver's license? Most likely you're going to have, an insurance company will think so. It is very obvious risk. That's why they will not even cover you. Or an inherent risk, where there's something occurring, but it cannot be avoided by the exercise of a reasonable care. So more likely than not, this is the first part, where there is an obvious risk. All right. I will cover a few cases, or do you want to have a break now and we come back later and we have another break before the tutorial? Shall we keep going? Let's go and look at the first case of Donahue and Stevenson. We'll continue. Page 125. This is one of the most celebrated cases in relation to negligence. As you can see, it's very old, from England. So, in 1928, Mrs. Donahue went into a cafe with a friend. This friend bought her a bottle of ginger beer. The manufacturer was Stevenson, hence Donahue and Stevenson. The manufacturer sold this ginger beer to the distributor, and the distributor sold it on, and eventually it reached this cafe. So there's a chain between the manufacturer all the way to Mrs. Donahue. The bottle containing the ginger beer was opaque. What does that mean, opaque? Is this an opaque bottle? Why? Because you can't see through it. So the key point, you can't see through it.
Well, is opaque mean you can't see through something?
Yeah. Is this opaque?
Yes.
Opaque generally means sort of.
What about a tube of toothpaste? Is that opaque? Can you see through it? Can you see through the toothpaste tube? Can you see what's inside? Until you start squeezing out, right? But you can't see everything. So this was an opaque bottle. It was also sealed by a metal cap. It was sealed. Sold, sealed. What does that mean? It means that making inspection of the contents, impossible. Okay. like toothpaste. It's opaque and it's sealed. Mrs. Donahue had no reason to suspect that this bottle contained anything but ginger beer. A reasonable person wouldn't think there's anything wrong. Shopkeeper poured. So we opened the seal and we poured some of the ginger beer over ice cream in glass. So now you have a glass, there's ice cream, and they poured the ginger beer on top of the ice cream. And Mrs. Donahue drank the contents. Now it's the friend who continued to pour more of the ginger beer into the glass. And it was at this point that it was alleged there was a decomposed snail. Do you eat snails?
Well, I could have.
In some countries? No, maybe? Where? How close is Scotland to France? Culturally?
I'm not sure. They're both country of Europe.
Do you eat snails in Scotland? No. No. Can you imagine any reason why a snail is going to even be in the proximity to a manufacturing process that produces ginger beer? Did they use it for something? Okay.
They probably didn't check the bottles before.
So, because of consuming some of this snail, Mrs. Donahue claimed that she suffered something called gastroenteritis. So gastroenteritis is something that affects your tummy, and that is a physical injury, just like a broken arm. But also, she suffered severe shock,
Anyone would.
just like some of you did just now. But this severe shock is not a physical injury. It is a psychological injury. And we call it mental harm. Okay, so the issue was, what is the issue here? Out of all of this, okay, let's start from the beginning. Are you trying to punish the manufacturer, or are you trying to get money? Donahue wants money, right? So is she going to go for something under criminal law or civil law?
Civil.
And under civil law, you think which kind of theory would help you the most? Well, the one we're discussing today, which is negligence. Okay. What do you need to establish under negligence? That there is a duty of care. Is there a duty of care here? Yes? Based on what? Based on what we talked about on page 126. And it says the first one is manufacturer of goods owes a duty to consumers. What's important in this case, because we're going to cover that next week, is this diagram. There's the manufacturer, and there's a chain of a retailer or more, and that chain will lead you to Donahue's friend, not to Donahue. And Donahue is the one who wants to get money from the manufacturer. Note how there's a gap between the chain of contracts that leads to Donahue and the manufacturer. So you cannot use contract theory to argue that there's a breach of contract between Donahue and the manufacturer. But you could argue that there is a contract between the friend and the manufacturer. Can the friend bring a cause of action against the manufacturer in contracts, you think? Maybe. Because you you can link them all the way back to the manufacturer. There's a contract between the manufacturer and the retailer, contract between the retailer and Donahue, and of course under the ACL today, you have other types of guarantees that will help you do so. But for our purposes, this was the first time ever that the court said Donahue has a right against the manufacturer in negligence. So that was the invention of this legal theory. All right. Let's look at Swain. So, the appellant, a swimmer, was injured when he hit a sandbar as the result of diving through a wave at Bondi Beach, okay, in small surf. Now, the jury found that he was injured while swimming between the flags. The lifeguards on duty could see the sandbars and would have been aware that there was a hazard. And the issue was, so this is the legal issue you need to identify if, for example, this was a question in the exam. Did the council owe a duty of care to users of this beach to place the flags properly so as to avoid the hazard of the sandbar? And had the council failed to warn Swain of the hazard? So whether there's a duty and whether it has been breached. So what did the court say? High Court. Both parties accepted that the council owed swimmers in a patrolled area a duty of care. So that's not the problem here. That's not the issue. In this case, the High Court of Australia found that the jury's verdict was one where it was reasonably open to a jury to conclude that the council's actions were unreasonable. So, as it says, the main issue was that of breach. So for purpose of the exam, if something like this comes, you know that there's a relationship between the council and the swimmer enough to find a duty of care. That's not the issue. The issue is, has that duty been breached? So the question is whether the lifesavers had acted reasonably and what standard of care could have been expected of the reasonable person in the circumstances. Okay. So that's the identification of your issue. So in the exam, you'll start the first issue, if there's more than one, you'll start with something like this, a question. Okay. The duty of care of the council then arose from the fact that it had care, management and control of the beach, thus creating a legal duty to take reasonable care for the safety of users. Okay. Swimmers should have been warned and the flags moved to a safer part of the beach. So what they're saying is that the sandbar is an opaque bottle. You can't see it. I mean, you can't see what's inside it. So I have to warn you. Okay. Case reflection. Do you agree with the High Court finding in favor of the plaintiff? Who's the plaintiff? The swimmer. Got money. Or did you feel that this places an unreasonable burden on local government when it comes to looking after the safety of people who use their facilities? Shouldn't those who go to the beach have to accept some responsibility for their conduct? Are you assuming voluntarily the risk of injury when you go and swim on the beach? Or you expect that nothing bad is going to happen to you? Yes, Tim.
Would lifesavers come under that immunity of fire and emergency services?
All right, we haven't gotten that far yet. I'm sure that's going to come in the future, especially if there's many people asking for money. You'll give them immunity. Not yet. So swimmers don't enjoy the same protection as fire brigades. Okay? Lifesavers, lifeguards. But again, we go back to this idea of if you go to the beach and there's a shark decides to come and say hi. Is the council responsible?
Yes, you should let people be aware that there is a shark in this water, and so
Yeah,
it's
but if they do that and they still get attacked, they're not responsible. Like, you know what I mean?
So if you warn,
There's safety procedures that they have to follow. So if they see a shark, they have to put the shark's siren on, get anyone out of the water. If you choose to stay in that water, you get attacked.
Okay.
That's on you.
so
There's some levels you have to go through for that.
it doesn't matter how I warn you, but once I warn you and you still go in, then that's what we call voluntary assumption of risk. If something happens to you, how much money do you get? 0. Okay?
There should be voluntary assumption when going into the ocean, like for any risk. because
Okay.
there's
We're
no-
getting there. We're getting there. So, if, say, you go to a beach that's notoriously known for shark attacks. So, many times in the past, people were attacked by sharks in that locale. Do I still have to warn you?
well, it should be.
Someone says yes. Someone says,
I was going to say no, but I was thinking if it's a known place for shark attacks, it should be common knowledge. And I was going to say maybe they should put signs all around the town saying this place is known for shark attacks. Beware.
But what if you're
You're a tourist, you have to go for it.
But don't they have those signs like out front before the flags that you read and the show you which way like
Yes.
the water's falling and like to say that there's a sandbar or a
Yeah.
green shark side?
Isn't there also a designated shark flag that they have to put up and say there are
Okay.
sharks in this vicinity?
Yes. And they do that because lifeguards can't go to every single person and tell them.
yeah,
They're meant
and
to be watching the beach.
what if it's an unpatrolled beach?
what if it's an unpatrolled beach?
And you have to have signs.
Then you're taking
Then you are taking that risk. What is all of this, if we want to sum this up? What is it that is driving these arguments? What is it? Your decisions, but you're, as someone who's going to use a beach, okay, you are now accustomed to a certain way of doing so. So you have an expectation. And if that expectation is met, then you can't turn around and say, oh, but I got injured. If it's not, or it changes over time, it's a different story. Okay? So the key point is that it's about expectations. Let me keep going a little bit more. Let's go to page 129. And this is the case of Wicks and the State Rail Authority of New South Wales. And it's also between Sheehan and the same authority.
So are these two people going against the same thing, or are they?
Yeah, and that is being heard together. So, the appellants, Wicks and Sheehan, were members of the police force who were among the first to arrive at the scene of a high-speed train derailment. A number of people were killed, and a number were severely injured. Both officers, Wicks and Sheehan, were involved in the recovery of bodies and rescuing survivors under difficult conditions, providing first aid and securing the scene. Both subsequently developed psychological and psychiatric conditions. For our purposes, if you want to bring a cause of action in negligence against this railway authority, your period of limitations is going to start from where? From the time the accident occurred or from the time that Wicks and Sheehan developed these injuries? No. Because that's the start of the what we call per se, actionable per se torts, i.e. where you don't have to prove injury. If you have to prove injury, it has to start from the time they developed psychological and psychiatric conditions, because that could take a while. And if you started from the act, they might not actually be able to bring the action. Both sued the authority, alleging that the negligence had caused them to suffer pure mental harm. Pure in the sense that there was no physical injury, no broken arms. Now, this authority admitted that it was negligent. Okay? But the issue was, were they still liable for damages as they had not witnessed the victims being killed, injured, or put in peril by the act or omission of the authority? In a nutshell, can we argue that they get damages, money, for this pure mental harm? And the decision was, if the relevant duty of care was owed, then a section in their Civil Liability Act in New South Wales was satisfied. Okay? As both Wicks and Sheehan had witnessed others being injured and put in peril at the scene. Okay? The survivors of the derailment remained at risk until rescued. So the consequences of the derailment took time to play and did not stop when the carriages came to rest. So the pure mental harm is caused and connected with the events that these officers were involved in. In the comment, it says, before consideration can be given to this section, okay, it must first be established that Section 32 is satisfied. That is, the authority owed the two police officers a duty of care. So this is the first element, the existence. In the context of a duty of care, the High Court noted that foreseeability remains the central determinant of a duty of care. So that's the really legal test, reasonable foreseeability. A duty which is a question of law and for the courts to decide. But note that in this case, the plaintiffs had not witnessed the death of the victims. Okay? The High Court suggested that when considering the duty questions in cases involving psychiatric harm, and that's what we want, the question, okay, is, was it reasonably foreseeable that sight of the kind a rescuer might see, sounds of the kind a rescuer might hear, and tasks of the kind a rescuer might have to undertake to try to ease the suffering of others and take them to safety would be, in combination, i.e. all of these things together, such as might cause a person of normal fortitude, the reasonable person, to develop a recognized psychiatric illness. So if something happens and because of that you develop a psychiatric illness, you can recover. But if you already have a psychiatric illness and you cause someone else the harm, the court will not take into account that psychiatric illness. It doesn't make sense. So they say the standard of care doesn't change if you are the one who caused it and you have a psychiatric illness. Okay, case reflection. If all the passengers on the train had been killed, all of them, okay, would the police officers who arrived at the scene be subject to the limitations in Section 32A? So in other words, how would that affect their psychiatric illness? Would you suffer more psychiatric harm when you are dealing with someone dying, or when you come and find that everyone is dead already? Okay, we'll leave that for your reflection. Let's move on with maybe just a few more. Let's look at the lighting case. The lighting case on page 132. Goldman and Hargrave. A tree on Goldman's farm was struck by lightning and caught fire. Goldman had the tree cut down and left the stump to burn itself out. 3 days later, the wind freshened and the fire revived, and because of the dry state of the land, the fire spread to Goldman's neighbors, which is Hargrave, to his land, to Hargrave's land. Let's go back to the elements. The first element, is there any duty of care of a neighbor towards his neighbor? And if you go back to Durham and Stevenson, that's what they called it, the neighbor principle, because there's proximity between them. So, as far as duty of care, we know that there's a duty of care. The question then is what? The issue. Was that duty breached? Was leaving the stump to burn a reasonable step to take to ensure that the fire wouldn't flare up again, given the dry conditions? Was Goldman under a positive duty to take reasonable steps to reduce the risk? The decision, Goldman was liable. Why? Because the hazard could have been removed with little effort and no expenditure.
They've also maybe made the tree a bit more wet.
How can you link this back to what we talked about in relation to the CLA? So what did we say about the CLA? They said that you have to look at certain factors. So let's look at page 139. So we're trying to move away from the 1967. This happened in 1967. So I'm not worried about how they came to that decision, because we're not in 1967. I wanted to take those facts and apply them to what we have today, which is the CLA, and we looked at this. So if you want to look at whether there was a breach today, you have to ask the question, was the risk foreseeable? I.e., this stump catching fire. Was it a risk which the person knew or ought to have known about? Goldman, did he know? He's a farmer. And then you had to go whether the risk was not insignificant. What kind of fact are you going to use to argue that the risk here was not insignificant?
Had he not known about the tree getting struck by lightning, catching on fire, then he would be liable. But because he cut the tree down because he knew that it had been struck by lightning and he let it burn out, that decision of him leaving it to burn out knew that there was a risk.
Okay, but I want one piece of fact from the case itself that tells you that the risk was not insignificant. Yes? Thank you. What if it was raining? Do I have to do anything? No. There's heavy rain. We're going to be flooded in a few hours. Toowoomba is going to be flooded. I know. It's going to be so damp. But it is the dry conditions that made it not insignificant. So you see how you take the facts and you throw them at the questions? Let's move on. I want to talk about something called res ipsa loquitur. And res ipsa loquitur is discussed on page 141. No. We want to go to page 142. So this is basically a defense. In other words, you're going to say that there was a duty. Okay? What do you need? What do you need for res ipsa loquitur to work out? So it's basically the facts speak for themselves. A rule of evidence that allows you to treat the actual facts as evidence of the defendant's negligence. You're trying to short circuit all the analysis and go directly and say there was negligence. What do you need? First, so these are the elements of res ipsa loquitur. The first, the plaintiff's injury was one that ordinarily would not happen if proper care has been taken. And the plaintiff was injured by something with the exclusive control of the defendant, and that there is an absence of explanation and no room for inference. Can you use this rule of evidence when you argue Embry? Embry and McNeely, the 16-year-old driver, do you think you can make all of these elements on those facts? Most likely. So something you can work with. For example, if you get something like that in the exam, there are other things you can do. Let's look at two examples of the application of this rule. A train door fell open shortly after the train had left the station. So I would, for example, take this case and combine it with the Sheehan case, Wixon Sheehan, and make it into a larger exam question. We start the accident that the police officers went to attend from here. We combine the facts. A train door fell open shortly, just letting you know. A train door fell open shortly after the train had left the station, resulting in the plaintiff falling out of the train and being injured. The plaintiff pleaded that res ipsa loquitur applied. Why? Since accidents of this sort would not happen usually if proper care is taken, and this was something within the exclusive control of the railway company. The third thing that they should also mention is that there's no other explanation. Okay? The three elements are made. That's the argument of the plaintiff, G. The issue. Is the railway company liable despite the plaintiff only being able to infer negligence? This is how you infer from the facts that there's nothing else you could argue. The railway company was liable as they were in control of closing the doors, and there was no opportunity for third-party interference. So no one else could do that, opening the doors, and they were held to have been negligent. Okay. Memory. The plaintiff entered a timber shed of the defendant to buy some timber. What is the relationship between these two people? Is there a duty here? Does that duty exist? Yeah? Why?
Because the plaintiff is a customer and the person who owns the timber shop has a...
Manufacturer?
The manufacturer has an obligation to said customer.
Or, closer to the facts, thank you. The defendant is the what? He's the occupier. His premises is what? The timber shed. And the plaintiff is the person that came to his premises, to his property. So is there a duty? Yeah. Do you need to argue it? No. You just write one sentence. No issue here. Where is the issue? So, did res ipsa loquitur apply? So they're saying, I'm not just interested in this first element. I'm going to go through the whole shortcut and make the second and the third elements. So, they said, here, this evidence rule failed. Why? The physical cause of the accident was the wood flying from the saw. We haven't finished actually the facts. As this plaintiff was walking over to the foreman who was using a circular saw cutting some timber, he was hit in the face by a flying piece of wood and badly injured, physical injury. He pleaded res ipsa loquitur. You're in control. There's no one else in control. So he said, first of all, this ordinarily wouldn't happen. You don't go into these places and you're hit in your face. And you are exclusively in control of the saw. And there's no other explanation. Makes sense. There's nothing else. No. The court said this. Sorry. Thank you. It said the physical cause of the accident was the wood flying from the saw. But there was no evidence to show that the occurrence of that was due to the negligence of the employer's foreman. What does that mean?
Means that there was no evidence that the employee was negligent.
Okay, so you are in the shed, you're cutting this timber. What kind of duty is on you when someone comes into the shed? Or in other ways, was there a voluntary assumption of risk in this case? Or maybe even contributory negligence? That would be, I think, a better analysis of this case. What did this plaintiff do wrong? Okay. Okay. All right. So, which actually element did they fail on? If you go back to this, let's just stick with res ipsa loquitur. Which one do you think they failed on? The first one says there has to be the injury. So this injury to your face was one that ordinarily would not happen if proper care had been taken. What do you think? It's a shed.
Yeah.
It's a timber shed. Okay. What do you do there? You cut timber. What kind of care more they should have done in order to prevent this risk?
Probably put up a sign that says, if cutting timber, don't come too close.
Okay. Do you need a sign to tell you that there's a shark when you can see the shark? Do you see the shark? Yes. The source of the risk is in front of you. You still need warning? But I still, yes.
A reasonable person wouldn't, because I wouldn't go anywhere near them.
Okay. So the first thing you would do, even though you are coming to their premises, is what? Is to look around. You see someone doing work. What? Okay. When you walk around the campus in the early morning and you find someone blowing tree leaves, and you saw them, you see them, and they see you, what happens next?
They generally stop.
Stop. Are they using a saw? But a reasonable person would stop. What should you have done as a reasonable person in the circumstances? Is to draw their attention. Or to wait until they see you. Then they stop and then you come in. Okay? Let's move on. We want to just do one more. Let's do obvious risk. Page 150. The respondent injured his neck after his bicycle collided with a sling chain strung across a path leading into a park owned by the council, the other occupier. There was no prohibition on riding bicycles in the park, so no signs, or on the pathway and no warning signs. Okay. The chain was similar in color to a new patch of the concrete that has been laid on the path underneath. And it was strung low on the ground. Wells had been riding slowly and carefully at the time of the accident. Why would you say that? How is that relevant to anything? So they're trying to tell you no contributory negligence, and did not see the chain until he was about 5 meters away from that chain, and it was too late to avoid it. When he had ridden the route previously, there had been no chain across the path. So he has done this before. Was this an obvious risk?
No,
Why not?
because it hadn't been there before, and this guy probably drove past it just thinking it would be like any other day, while then something completely different was there that he wasn't aware of. And
Let's be surgical. You always go to the jugular. What's the one fact that you are going to use to say this was not an obvious risk? Same color as the concrete. Does that make sense? Enough to say that it's not obvious? And it was low. And
It wasn't there yesterday.
it wasn't there yesterday, and no warning signs. If I change one of these in the exam, I expect you to pick on that. If I say it was red, if I say something else, whatever, you would say, oh, but this is similar to this case, but this is also different. So how does that change the answer? I'm not going to be that mean to you because you're not law students, so I don't have to worry. All right, so what did they say? The court was satisfied that in this case, the risk was not an obvious one. Why is that? The path commenced a short distance from a busy street where cyclists would be concerned about traffic. And because the sling chain was low to the ground and blended the color into the new concrete of the path underneath, a reasonable person in the position of the plaintiff would not have seen the chain. That's enough. Okay, let's have a break and we'll come back. Let's please come back at 10:15 and we will start on our tutorial. Thank you.